So thank you all for joining us today. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC here in New York City. I am joined by my colleague, Jiyae Hwang, who is also a senior associate at the firm. And today we're going to be talking about the EB2 National Interest Waiver. This is a green card option, and it's actually growing in popularity, particularly for entrepreneurs, and we'll talk about why that is. A few starting preliminary points before we dive into the presentation. The first is that although our firm does focus on business immigration, including the national interest waiver, we handle the full spectrum of U.S. immigration law. So whether you have an issue regarding family law, temporary visas such as student visas, visitor visas, etc., we would be very happy to help. So please don't hesitate to reach out to us. Also, this webinar is part of a series. We tend to do at least one webinar a week. After this presentation, you'll get an email where you'll be able to sign up for our future webinars, and we do hope to see you on those. And those webinars do, again, touch on both business immigration as well as other immigration topics. We post our full-length webinars to our YouTube channel. So this webinar is being recorded. And on our YouTube channel, you can find past versions of this webinar, our other webinars on other topics, as well as shorter videos. And again, those are on a variety of immigration topics. So we do hope you'll check those out. If you have a question during this presentation, please do reach out by either chat or the Q&A function on Zoom. I will be monitoring those. We will probably save questions for the end of the presentation, but we do plan to get through all questions. So please don't hesitate to reach out. Also, you will get this PowerPoint presentation after the presentation. You'll get the PowerPoint. So don't think you have to write down everything you're seeing on the screen. All right, without further ado, let's go ahead and dive in with Jiyae explaining what the National Interest Waiver is and its requirements.
All right, thank you so much, Dustin, for the introduction, and thanks everyone for joining us this morning. So, what is an NIW? What is a National Interest Waiver? So, the NIW, EB2 NIW, is a green card option that can be available when the applicant is able to persuade the government that you are coming to the United States to do something that is in the national interest. And let's break that down a little bit. So when we say national interest waiver, what is it waiving? Now, the NIW is a subset of the EB2 employment-based green card category. And when we say immigrant petition, that is, we're talking about an application for a green card, U.S. permanent resident status. And many of you may already know a green card gives somebody the ability to live permanently in the United States and work for any employer or not at all. Having a green card also opens up the pathway to U.S. citizenship. So it is a very valuable benefit. Now, in the general EB2 pathway, really, and I would say the majority of such cases filed under the EB2 category are employer-sponsored cases. By that, I mean you would typically have a U.S. employer who is offering you a job, a permanent job in the United States in the EB2 category. And that employer will go through what is called a labor certification test, which is really, testing the labor market to see if there is any other U.S. worker who is available and able and qualified and willing to take the particular position that is being offered to the foreign national. And only after the U.S. employer is able to prove that there is nobody, in fact, who can take that job, that's when the employer can go forward to sponsor the foreign national for the green card. Now, when we talk about national interest waivers, it is basically an exemption from that requirement to test the labor market, to, come forward with a U.S. job offer and to really have a U.S. employer, a U.S. company that is willing to go through that process to sponsor this person. So when we speak of national interest waivers, it is a pathway that foreign nationals themselves can use to self-petition for a green card. So you, as a foreign national individual, can drive forward this petition even if there is no U.S. job offer, even if you do not have a U.S. company that is willing to go through that. labor market test. And another benefit to that, related to that, is that the labor certification process can be very time consuming. And, it can even, the whole process can fail if you actually, there is a US person who is, minimally qualified and able and willing to take that job. So there are a lot of difficulties inherent to going through that process, but if you're able to meet the qualifications for an NIW, that means you're exempt from, all of those additional eligibility requirements. So in that way, it is more like a fast track towards a green card, and really advantageous because you can drive forward your own green card petition. Given that you meet all of the NIW requirements. So, what are those requirements? The NIW has a three-prong requirement based on a recent case that was promulgated in 2016. It's called Matter of Danisar. And in addition to that, the matter of Danisar case is basically what defines how you prove something is in the national interest, because national interest is a very, general term, and that can mean many different things. Therefore, there is a more structured way this national interest is defined. So we'll go into more detail about that. But in addition to that, you must also show that you meet the EB2 threshold requirement to get into the EB2 category as a whole. And for that, you need to either show that you have an advanced degree defined as a master's degree or higher. And you can also meet that requirement by having a bachelor's degree in your field and 5 or more years of progressive work experience in your field after you received your bachelor's, or by showing that you have exceptional ability in your particular field. And we'll go into a little bit more detail on the next slide as well. So, as I mentioned it a little bit before, you do not need an employer to apply for a national interest waiver. It is possible for a foreign national to self-petition for the green card pathway. And the waiver relates to the requirement to prove that the employer cannot find a qualified U.S. worker. So you do not need to go through the PERM labor certification process if you can show that your petition qualifies for the NIW. Finally, the other important note to go over here is that a lot of people think that the NIW is only for certain fields, like an engineering field, or natural sciences, or some people may think that the NIW is only well suited for people who have PhDs or things like that, and that is actually not the case. We have had successful results for clients in a variety of fields, and many of our clients are entrepreneurs. And really the important thing is not what your field is. And even if you're somebody in the philosophy or traditionally humanities field, really it is possible to qualify for an NIW, provided that what you're doing in the United States is persuasively going to have a large impact in your field. So what I want to say is, even if you are working in a very attractive STEM field, that in itself is likely not going to be enough to qualify your petition for the NIW, because the inquiry turns on a more specific question, which is not what your field is, but what are you coming into the United States to do in your field? So what is your project that is within that field that you're proposing to do, and what is the prospective impact of that particular project that you're doing in your field, not necessarily what is your field. So that is definitely something that I wanted to make sure that everyone understood. All right, so let's go on to the next slide. So we'll go over the threshold requirements to qualify under the EB2 classification for the green card petition. So either if you're going through the PERM process with a U.S. employer, or if you're applying for an NIW, the EB2 threshold is really the same. And there are two ways to meet the EB2 threshold. One is by showing a degree, either an advanced degree or the equivalent of an advanced degree. And an advanced degree here is defined as a master's degree or higher in the field. So for example, a PhD, obviously, or MBA, that's a master level degree. Even degrees like JD or MD degrees where you already need to have a bachelor's to gain admission to that kind of programs can qualify as an advanced degree on its own. If you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience after you have earned your bachelor's, you can also use that to qualify as an advanced degree holder. Now, when we speak of progressive work experience, it is very important how to prove that. Because when we speak of progressive work experience, we don't speak of, where work experience where your duties and responsibilities stay the same over the 5 years. You do need to be able to show through, detailed letters of employment confirmation from your previous employers that what you were doing in your job changed in complexity, changed in the level of, duties that you were responsible for as time went on. So maybe you can describe how your title has changed from junior associate to senior associate, or things like that. Or maybe you can show how the nature of the projects that you're part of has changed, and what kind of leadership roles that you played as time went on. And that kind of detail will really be necessary to be supported by detailed employment confirmation letters on company letterhead from your previous employer. So if you're using that route, it is important to substantiate the progressive work experience part as well. Now, there is another pathway to qualify for the EB2 threshold, and that is through showing that you have exceptional ability in the sciences, arts, or business. And that is a pathway that you can use if you don't have a bachelor's degree, if you don't have a master's degree, but you do have other types of evidences that nevertheless show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in the field. Now, one thing to note is that when we speak of exceptional ability, it is a much lower standard than extraordinary ability, which we speak of very often in EB1A or O1 context. And in the EB1A or O1A context, when we speak of extraordinary ability, we're really looking for someone who has reached the very, very top of their field of endeavor, the small percentage who have reached the top. But when we speak of exceptional ability, it is a much lower standard than that. You only need to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered. However, you do need to show at least 3 out of the evidentiary types that we have listed here. So, for example, if you have any diploma or certificate or degree, you would use that. If you have, 10 years of full-time experience, you would get employment confirmation letters from your previous employers to substantiate that. High salary, if you are someone who commands a high salary, you would also provide evidence regarding that. Now, what's important here is that what the government is looking for is, in totality, sufficient evidence that shows that you're someone who has received some sort of distinction in your field, right? So when we speak of the last factor here, recognition for your achievements and significant contributions to your industry by your peers, I think that is an important evidentiary standard to keep note of. Let's say you've, published some papers that have been cited a high number of times. That can be one way of saying something like that. If you can get, letters of recommendation or expert letters that confirm how what you've been doing in your industry is leading or outstanding, those expert letters can also serve as kind of an evidence that serves as recognition, right? If you've, been recognized in your industry by awards or, honorable mentions, or if you've developed a product that has been shortlisted in industry awards or things like that, all of those things can, be used to show recognition. So there is definitely a lot of room for advocacy when you're looking at your profile to see what you can pull together to meet the evidentiary criteria for exceptional ability. All right, so now once you have shown that you meet the EB2 threshold, the next challenge is to provide enough evidence to persuade the government that you meet all 3 prongs of the matter of Danaher test. And that, I think, is pretty much the main challenge of an NIW petition. And let's go through that. So the NIW requirements. The first prong test is to show the government that the applicant's proposed endeavor has substantial merit and national importance. And let's break down in a little bit more detail what that means. So step one in the NIW process, and I would say it's, yeah, a very critical one to do right, is to clearly define your proposed endeavor. And the proposed endeavor must be more specific than simply saying, I'm coming into the United States to work as an engineer, or I'm coming into the United States to work as a nurse, or I'm coming into the United States to work as a pilot. Any of these one sentence answers would definitely not be enough to, you know, get you to an approval for an NIW, because what the government is looking for is a plan, a project that you're planning to advance that is more than simply working in an occupation. And the reason why they ask for more than that is because they already have the PERM process. They already have the labor certification process to, get workers who are simply, filling the needs of the labor market, right? And they do have the requirement that a U.S. employer must, prove that there is no other U.S. qualified and able and willing U.S. worker to fill that job. But when you're asking for a waiver of that requirement, you need to show that there is something special about what you're doing in your occupation that, merits such special treatment, right? That is why they're asking for that. Now, one thing to note is that the geographic scope of the project is no longer the focus, right? Which actually does open the pathway to a broader array of potential proposed endeavors. So, for example, if you're working with a population of veterans in a single area, even if geographically your office is located and focused on that particular single region, if the impact of your work can go beyond, simply providing services. For example, if what you're doing will, provide a role model for how services can be improved, and, maybe you will influence, other states and other regions to also try that kind of project, then you can show, national impact, even if your physical location is only concentrated in our particular region. And really, the geographic scope is not what you would focus on when you're trying to talk about the impact of your work. You will talk more in, in qualitative terms about why your work will benefit the field in a broader way, because maybe you're improving something, or maybe you're, helping the advancement of scientific knowledge in a particular field. Anything that can show that your work goes above and beyond what is ordinarily encountered. So that's the kind of focus that we're usually seeing after matter of dinosaur. Geographic scope is no longer the determinative factor. So endeavors that have broader implications in the field, such as improved manufacturing processes, medical advances, or substantial positive economic effects, such as maybe you're bringing in a high amount of investment in a economically depressed area. If you, are hiring a high number of workers in a particular region that is significant with respect to, the total population of that area. Endeavors like that can certainly be argued to have national importance, regardless of the actual geographic footprint of that particular project. Now, when we speak of broader impact to the field, we're talking about benefits that go beyond one's immediate employer or clients. So let's say when you're speaking of a proposed endeavor where I will, benefit my employer by, adapting existing code to, the employer's specifications. So if that's all that you're doing, right? And if the government can say, wait, it just seems like what you're doing is applying existing knowledge for the benefit of only one particular company. It is possible for that NIW petition to be denied for lack of national importance, because you haven't really shown what would be the broader impact to the field itself, or, to the nation more broadly. By that particular work. By contrast, let's say, you're developing a new technology within engineering, which can, really improve the way, I don't know, chips are arranged in a particular machine, right? And let's say this is something that a lot of companies are, struggling to overcome this limitation. And whoever does this, the other companies will inevitably follow on with, using that similar approach. And maybe that solution can also be patented. And if it is patented, then other companies can license that solution and use that technology to improve their products as well. So if you can, show things like that, right? Kind of a ripple effect of technological advancement. Like those are the kind of things that the government will see. Oh, okay, it looks like not only is this work going to, positively impact the immediate employer or clients that the person is immediately working with, but the ripple effects from that particular innovation will, reach the entire field and result in improving best practices in some way. And not everything needs to be revolutionary, but it does need to be something that's more than just doing what is already there. So definitely, I would say that's an important thing to consider when you are crafting your proposed endeavor. Substantial merit and national importance. There is a little bit of a difference between those two concepts. Substantial merit is often the easier standard to meet, anything that can benefit the society or benefit, provide some benefit to the area could be seen as something of substantial merit. But national importance is the key here because an endeavor can have substantial merit even if it, tends to benefit just a small scale of, your immediate client base. But in order to meet the national importance standard, you need to show a broader benefit than that. Let's see. Job shortage issues in the United States does not mean that the profession rises to the level of national importance. And the good example of that is pilots. Now, there has been a lot of speculation online whether, if I'm a pilot and if I, say that the US has a shortage of pilots and if I propose that I will work in the United States as a pilot, does that mean I qualify for the NIW green card pathway? And the answer to that is actually no, because just by showing a job shortage in a particular profession, that doesn't mean that any pilot will be approved for a green card based on the NIW, because Congress already has a way to deal with that job shortage, which is the traditional labor certification requirement. So if you apply for an NIW and if your proposed endeavor is just to work in the United States as a pilot because there is a job shortage, the government will come back at you and say, well, too bad. Why don't you go and get a US employer who is willing to sponsor you for that particular job? Because that is the way labor certification and sponsorship is the way that Congress intended to resolve job shortages like that. So definitely. It is important to speak to a lawyer who understands the applicable laws and standards. We've seen, a lot of consultations where people would come in and ask us about that particular argument, and we would tell them that that unfortunately will not work. Several appeals cases also point out relevant measures for national importance, and it is, and they talk about teachers as an example, right? As an example of an endeavor that may have difficulty meeting the national importance standard. And their reasoning why is that if you are proposing to work as a teacher in the United States, right? When we think about the work of a teacher, you would benefit the immediate students who attend your classes and to whom you can provide the teaching. But are you actually providing, a sort of an innovation or kind of a more of a broader impact to the field of teaching as a whole, or the field of your particular industry or field of profession as a whole, right? So we've seen AAO cases where someone was trying to apply for an NIW, and this person had a background in the sciences, and their expertise was twofold. Well, the part of their proposed endeavor was twofold. One of the proposed endeavor related to doing more research on that particular field of science and publishing that research to help with, improving scientific knowledge in that particular field. But another part of that proposed endeavor was that this person would teach at universities and, help students by, this teaching activities. Now, there are many decisions from the AAO that distinguish between those two types of endeavors and say, okay, the first type of endeavor where this person is, producing new knowledge and sharing that knowledge to have a broader impact to other experts in the field, that one meets the national importance standard. But when they would look at the teaching part of the endeavor, it is, we've seen many cases from the AAO that come in and say, well, the teaching part of this endeavor actually does not meet the national importance standard because teaching endeavors only tend to benefit the immediate students who attend that teaching, as opposed to an endeavor that, advances best practices in the field as a whole. So definitely a lot of nuances here to look out for when you're crafting a proposed endeavor that meets the national importance standard. All right, so the second matter of DANISR criteria is that the applicant must be able to show that they are well positioned to advance this endeavor, which, that we have just shown that is in, has national importance and substantial merit, right? So how do you show that you yourself are well positioned? And here, the focus is on the individual, not necessarily on the impact of the prospective impact of the endeavor itself. So you would need to provide enough information about your own background, experience, education, and show a track record of success or influence in the field to prove that you have, what is needed to, provide that impact to the field that we have just argued in prong one. So let's talk about patents and intellectual property. Having had published intellectual property products in the past, that definitely can help if you have a record of that to show that you are well positioned to continue advancing, continue pushing the envelope in your field in the future. Another thing to note especially when we're working with entrepreneurial endeavors, if the endeavor has made a lot of progress, for example, if you're already in the United States on an E2 visa, and if you've already developed and directed the business to a very prosperous state, and maybe you have, gotten a lot of third-party attention about your project, and perhaps the, the prospective impact of your project can be supported by things like, maybe you've been gained admission to an incubator, a prestigious accelerator, perhaps, or maybe you've received a substantial amount of venture capital funding from, leading venture capital entities. Those types of, objective confirmations of the value of the business idea that can be shown through the progress of your business endeavor, that can actually be very helpful when you're proving well positioned as well, because having you at the helm, the business project has gone to that point. Those types of evidences can be very helpful. Other type of evidences that can be helpful, expert letters from people who know of your work or people that you've worked before in previous projects, previous employer contexts. Very detailed letters describing the things that you have done and why this would qualify as successes in your field. Those types of evidences can also be very helpful. If you have a business entity that already is running, and if you're trying to qualify for the NIW with that business endeavor, if you have contracts with major U.S. industry actors, tax returns showing a history of revenue growth that can support projections of future growth and significant job creation in the past, that can also show, the prospective expansion of this hiring in the future. All of those types of objective data can be helpful in proving that you're well positioned to continue driving forward this important endeavor. The final requirement, the third requirement in the matter of DANISR test, is that the applicant needs to show that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And that essentially is a balancing test. So we want to, mix and match from any, compelling persuasive pieces of evidence in, either that we use for prong one or either that we use for prong two to, highlight why it would be beneficial to have you come in and do your unique work that really cannot be replaced by another U.S. worker with minimal job credentials, minimal educational credentials, or requirements for the job, because the ordinary benefits of the labor certification, requirement, right? The requirement that has U.S. employers, needing to test the labor market to see if there's somebody else who can take your job before that job can be offered to the foreign national. It can be outweighed if, you know, the systemic benefits to your particular field, or the substantial economic benefits, that your particular endeavor will produce, will, be greater and more significant than the ordinary benefits of, preserving that job spot for a U.S. worker in the ordinary circumstance, right? So, the more outstanding, you can paint your profile as, the more compelling the balancing test would be. And specifically for entrepreneurs, you may have a leg up in prong three as well. One argument that you can use is that usually entrepreneurs are not able to practically take advantage of the traditional labor certification pathway, because frequently they have ownership interest in their businesses, and in that case you can't go through that traditional pathway of sponsorship. So that's one argument you can use. Another argument you can use is really focus on job creation. If your business endeavor will create a high number of jobs for U.S. citizens, for U.S. permanent residents, then that is already, counterbalance to, the interests that Congress had in preserving and protecting the U.S. labor job supply. So that for that, entrepreneurs can have a variety of arguments they could use in their toolbox. So, Matter of Janisar specifically notes that entrepreneurial work can indeed lead to a green card under the NIW pathway. So, it definitely remains a viable option for entrepreneurs. So, I'll talk just a little bit more about national importance before handing it off to Dustin, and he will take us through some other considerations. And I'll just quickly go through the bullets. So, in order to present a compelling national importance argument, you need to prove the importance of the individual's specific proposed endeavor, not the importance of the field or occupation the individual will be working in. Expert letters can be a very important part of proving national importance. Because expert letters can discuss what is, the limitation or the status quo in the field, and what is the prospective impact of what the applicant can bring, and what are the expected benefits that are broader than just, providing existing services, doing, providing, offering something that already exists in the ordinary state of affairs. Benefits to one specific employer alone will usually not be enough. And I had the example of an engineer who only, works to adapt existing codes for the benefit of that particular employer who is hiring the engineer. Broader impacts to a field or region or the public at large is key to providing a claim for national importance. And here are some examples. A person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to the employer. Widespread interest in adopting or licensing a particular technology, a novel and important manufacturing process, or how the technology stands to impact the development of similar technology by other companies. And these quotes are from the USCIS policy manual itself. So definitely they provide some color to what kind of proposed endeavors could work well for the national importance argument. Substantial economic benefit can also be a pathway to show national importance. creation of U.S. jobs, creation of a number of U.S. jobs at a level that is significant with respect to a population or economy of a region. And note that there is this sort of a comparison that's going on. So they're definitely not looking for, kind of a job number in the dozens or, low tens or things like that. But they're definitely looking for more of a significant with respect to a region's particular circumstances. So definitely can be a factual analysis that's highly dependent on where your particular business is located when we're speaking of substantial job creation. All right.
Great.
So
Thank you so much, GA, for the excellent information. I am going to slightly switch gears here, although GA actually did touch on a lot of what I'm going to be covering over the next few slides. In terms of this slide, what is included in a national interest waiver submission? I think there are a couple important overarching points to keep in mind here. The first is something GA said, which is this is your opportunity to advocate for yourself. This is not an opportunity to hold things back, to be conservative. You really do want to think, okay, to show the government that I am qualified to pursue the proposed endeavor, what is anything I can show the government that I'm qualified? To show that my proposed endeavor is in the national interest, is there anything I can show? Are there newspaper articles? Are there videos where I could get screenshots? I can get transcripts of the video. Have I done interviews? Are there blog posts? Are there patents? I mean, you really want to, are there letters that I could get from really anyone? Don't just think, well, because it's not the CEO, then I don't want to include this letter. You really do want to think, is there any piece of evidence that I can include in this application to make my case? And this is really something that even if you engage a lawyer, you still are going to need to play a significant role in this, because a lawyer cannot tell you what evidence is out there showing that might show the government how well equipped you are or how significant and beneficial your enterprise is. You really are the expert on knowing, oh, well, 15 years ago, I got an award. Or 10 years ago, I worked for this person who might be willing to write me a letter. A lawyer can't tell you that. So it really is your opportunity to cast a very broad net and think broadly about what you might include. But to be a little more specific, keep in mind what GA said, where a national interest petition really does come down to a few buckets of evidence. The first bucket of evidence is, do you meet the threshold requirement? And that's usually a straightforward bucket. If you are showing that you you don't have the degree necessarily or the experience, then you will have to include more evidence showing that you meet 3 of the 7 criteria to show exceptional ability. But that is one bucket, is meeting that threshold requirement. Either I have the advanced degree, work experience, or I satisfy at least 3 of the 7 criteria. That's one bucket. The second bucket is really about the importance of the proposed endeavor. So you want to show that it's not about you as an individual, it really is about your proposed endeavor, showing that it is of national importance and of substantial benefit to the United States. So that's your second bucket of evidence. Your third bucket of evidence is going to be that it's about you as an individual and that you are well equipped to pursue that proposed endeavor. So for each of those buckets, you are thinking about, okay, what are the best arguments I have that I'm well equipped and that my proposed endeavor is of national importance and substantial merit? And then I'm making these arguments that I am well equipped and that the proposed endeavor has national importance and substantial merit. What are the pieces of evidence that back up my arguments? And you always want to back up your arguments with evidence. Just assume that the government is not going to take anything you say at face value. They're going to want to see a copy of the award. They're going to want to see a copy of your diploma. They're going to want to see a signed letter from that expert. more than just you saying, well, I got this award, or I got this grant, or I have, this expert who's willing to speak to my ability. So what you see on your screen are more specific examples of what I've just said. I'm not going to get into detail now for two reasons. First is that Jiyae already went into a number of these. Second of all, you will get a copy of this presentation, so you'll have this list as well. And if you have questions about any of this, or if you want to brainstorm with a lawyer, we are, of course, happy to do that through a consultation. So, what are some recent trends and strategies that we have seen in the national interest space? The first is we have seen an increase in filings for national interest waivers. I think that there are a few main reasons for this. One is what Jiyae mentioned, that in 2017, the government issued the matter of Danisar decision. That we as attorneys see that decision as very beneficial to applicants. First of all, it created a quite clear standard for meeting the NIW requirements, which we've shared with you during this presentation. But the second reason is that it made very clear, that decision made very clear that entrepreneurs qualify for a national interest waiver. Before the matter of Danisar, it was debated whether an entrepreneur could qualify. Now we clearly know an entrepreneur can qualify. And I'll just quickly add to that, not only can an entrepreneur qualify, and it is ideal if that entrepreneur has not only created jobs, but has also created a business or an enterprise or an endeavor that is pursuing, some aspect that is of national importance. Say it's a business that engages in very specialized and important research, or it is a business that attempts to address a significant societal issue. The example I'll use is creating support programs for veterans, which is a real case that was approved for an NIW. While it is good to have that focus, it is actually possible to qualify for an NIW based on job creation alone. Now, as Jiyae said, the number of jobs created do need to be significant. We're not talking about 10 jobs. We in general are talking about dozens of jobs. But that being said, it is a significant step that the government is willing to approve NIW applications for entrepreneurs, first of all, and second of all, for entrepreneurs based on job creation alone. So I think that's a couple of the big reasons that we're seeing an increase in these filings. And related to that real quickly, the most common visa that we help our clients navigate is the E2 visa. And the NIW really is, along with the EB5, probably the best green card option for an E2, an individual who has an E2 and has been building a business in the US. So I think that is in part the other reason why the NIW is so popular, is that not only is it well suited to entrepreneurs, but I think we have seen the E2 also grow in popularity. And so therefore, for those E2 visa holders who want a green card option, the NIW does tend to make sense. Second of all, though, along with the increase in recent filings, we are seeing an increase in requests for evidence and denial rates. Now, that I would say does not necessarily apply to our firm in terms of the denial rates. Obviously, past performance doesn't predict future outcomes. However, we do see RFEs. We do see the government come back and want additional clarification, additional evidence substantiating the claims we're making in applications. So I would say if you are planning to go the national interest waiver route, be prepared to support any claims you make with evidence. Be prepared to pull together with your lawyer a robust application. And this is also informing another topic that Jiyae mentioned, which is applications regarding pilots. I think the NIW space, maybe more than a lot of other visas, you'll see a lot of rumors going around that do affect trends. One of the rumors that became very popular is that pilots are eligible. that pilots are eligible based primarily on the fact that the US has a shortage of pilots. And that is, generally speaking, just not true. Pilots can be approved, but they generally need to have much more than just the fact that they are a pilot. If you have questions about that, we're happy to talk about that more in a consultation. But I think because you're seeing these trends where word will get out that a certain group is eligible and you will see a wave of applications, regardless of whether it's true that the class of people is eligible, that has also contributed to a rise in RFEs and a rise in denial rates. So that all just goes to say that it is worth talking with your lawyer, making sure that your specific circumstances are NIW worthy before you dive into the process and spend the time and money that it requires. Third point, the government has recently issued policy guidance that clarified some NIW aspects. One of the main areas is the importance of proposed endeavors related to STEM fields, science, technology, engineering, math. Under the Biden administration, the government did issue some quite favorable guidance saying that if you are working in a STEM field, if you have background as a STEM worker, a STEM expert, then that does give you a leg up in the NIW space. However, under the Trump administration, some of that guidance has been revoked. And that guidance, the guidance that has not been revoked, it's not clear how much weight the government is actually going to give it. So I don't think that in and of itself should determine whether you apply or not. I do think it is important to keep in mind that maybe some of the benefit you would have gotten a year ago might not be present. But that being said, our experience is that these applications are very much still being approved. So even whether or not you're in a STEM field, we would still make those arguments. It's not that you should be the one to say no to those arguments. Let the government be the one to say no to those arguments. And finally, entrepreneur-specific strategies. We've already talked quite a bit about this. Danisar, actually the case itself, gives some very good language about some worthy strategies for entrepreneurs. In general, I'm not going to go into detail on what you see on your screen. These are really examples of things to keep in mind. If you're an entrepreneur applying for an NIW, think about, again, the best evidence that if you were to sit down with a government officer who knows nothing about what you've been working on, what are the pieces of evidence you would show them to show that the business you're creating really does have substantial merit and national importance? What can you show to show that you're employing workers? What can you provide to show that the business is working on a worthwhile cause? What can you provide to show that you are well equipped to guide that endeavor? Have you led past businesses? Can you show proof of the success of those past businesses? Are there articles about you? Is a government agency willing to write a letter talking about the importance of your business? Think broadly. Again, this really is an opportunity to advocate for yourself. A few points on timing considerations and other considerations. So basically, let's actually start with the application process. The first step to apply for an NIW is to file with USCIS, what's called a Form I-140. The I-140 is a form that really is your opportunity to show the government that you meet the EB2, which is the second preference green card category, EB2 national interest waiver qualifications. So you file that application, that really is going to have all of the evidence that we have been talking about in this presentation so far. That is part one. If your I-140 is approved, it does not mean that you are issued a green card. To get a green card, you need to also do step two, which is either to file for an adjustment of status if you're inside the US, and that is done by filing a Form I-485, or if you are outside the US or you're inside the US and you want to apply at a consulate, you will file a DS-260 with a consulate. That's the second part. So if your I-485 is approved, then you will be approved. Your adjustment of status will be approved. You will be issued a green card. If your DS-260 is approved, you will go to the consulate. You'll have your interview. Then the application would be approved, and you'll receive the green card from the consulate, and you'll enter the U.S. with that. I'm sorry, you will not receive a green card at the. You'll receive an immigrant visa at the consulate. When you enter the U.S., you'll actually receive your green card. So those are the two pathways for that second part of the application. So let's quickly talk one quick additional point. You cannot file the second part of the process, whether that's an adjustment of status or the DS-260, until you're current on the visa bulletin. So this does get a little confusing. We are very happy to talk with you over a consultation about what this means, but a very important resource is the Department of State's Visa Bulletin, and you can Google that right now, and you will see a table, and it will have second preference, employment-based second preference category. In order to file your adjustment of status application or your DS-260, you do need to be current according to that table. So just by filing the I-140 does not mean you can file the DS-260 or the I-485. You do need to look at that table and make sure that your priority date is current, or that the category itself has a C in it, meaning that it's current and they're accepting green card applications. And if the category is current, it means that green cards are available to you. And there is that backlog just because there are a limited number of green cards made available each year, and there's a long line of people waiting for them. So if your category is not current, it's because there's a backlog of people waiting for the green cards. So let's talk about timing. Fortunately, there is premium processing available for the I-140 for that first step of the process. The premium processing, it does cost a few $1,000s. I think it's $2,805 last time I checked. Once you submit the I-140, if you pay that fee, file the I-907 for premium processing, you will get a decision within 45 business days. Now, a decision is either an approval, a denial, or a request for evidence, or a notice of intent to deny, or annoyed. You'll get one of those. Any of those is considered a decision. So let's say that you get an approval. Wonderful. You'll be able to then have that approval, and when your category is current, you'll be able to file the I-485 or the DS-260 if you want to apply to consulate. If you get an RFE, then you will respond to the RFE within the time frame they give you, and then the government has another 45 business days to give you a response. That could be another RFE, it could be annoyed, or it could be a decision, approve or deny. But that premium processing really is a great benefit if you want a decision quickly, meaning within 45 business days. If you don't pay for premium processing, you are looking at about a year before you get a decision on that I-140. Now, we talked before about how there are the two pathways: adjusting status within the US or applying for an immigrant visa at a consulate. If you file an application, file an I-140, what it is doing is it is showing the government that you intend to apply for a green card. You intend to remain in the US permanently. If you are currently in the US on a visa, for example, a TN visa, an E2 visa, etc., those visas require, in general, that you have the intent to leave the US at the end of your status. So if you file an I-140 and you represent to the government that you do ultimately intend to remain in the US permanently, it could make it more difficult either to enter the US on a temporary visa or to apply for a temporary visa. So one of the recommendations is that you renew that temporary visa before you file the I-140 so that you have a new period of time to come into and out of the US before the I-140 is filed. But the other recommendation is that when you file the I-140, you choose consular processing. And by choosing consular processing, if you ever do face scrutiny at the border and they say, hey, I see you filed an I-140, why should I let you into the US on a TN visa? You can say, well, first of all, I filed with consular processing, so I have to leave the US to get that immigrant visa. I'm not going to be adjusting status in the US and staying here on this visit. Um, the other thing you can point to is the backlog, is the visa bulletin. And if it is several years before your category is going to be current, you can say, look, it's going to be a few years before I'm even eligible for the green card. So I'm going to be leaving in that time. I'm not planning to stay in the US on this visit. And pursuing a green card on this visit. And that is important. So that's one of the real benefits. And in general, our recommendation is to apply using consular processing on the I-140. However, if you do choose to adjust status, and for many people, adjusting status does make a lot of sense. Adjusting status with the I-140, one of the benefits is, again, once your category is current, when you file the I-485, you can also apply for travel authorization as well as a work permit. And even though you cannot premium process the I-485, you cannot premium process the travel permit or the work permit in this category. So you do need to be willing and able to wait in the US for could be 6 months, could be 9 months before you get that travel authorization to travel. If you have underlying status, such as an E2, you can continue to work on the E2. If you don't have underlying work authorization, so let's say you're in the US as a student on an F1 visa and you're filing an NIW, let's say you don't have work authorization on the F1, then you're not going to be able to work until you get that work permit through the I-765, through the green card application. But if you can wait that period or you have underlying status that allows you to work, then adjusting status in the US can make sense. Again, you need to be able to stay in the US for a few months after that application is filed, or else you abandon the application. All right, so is the EB2 category current? It is not. We'll just quickly pull up the bulletin since I'm talking about it. If we pull up right now, the July bulletin is the most recent one, and we go to the second category. Right now, if you are applying from a country other than China, India, Mexico, or the Philippines, they are accepting applications filed in late 2023. So you're looking at about a year and a half delay for those countries. If you're from China, you're looking at right now, they're looking at applications filed in late 2020. So you're looking at 4.5 years. So you really are looking at a few years on this, but do monitor that visa bulletin. It's published every month, and it does at times move. So we've talked about the pros and cons of adjusting status versus consular processing. This can be a complex area, especially if you have an underlying status. So do schedule a consultation if you have any questions at all about that. We have a case study here. I'm not going to go into detail on the case study, but if you're interested, when you get the PowerPoint and the email that we will send to you after the presentation, this is a helpful example, and it is based on a real example. And again, I think what you're going to see here is these two main prongs, which are whether the proposed endeavor is in the national interest and of substantial merit. And second of all, that the applicant is the best person, is well positioned to move that proposed endeavor forward. So do take some time with that. Since we only have a minute left, a few seconds left, if there are any last minute questions, please do feel free to send those in. And Jiyae, if you had any last minute thoughts in the meantime, please feel free.
Yeah, no, I think we definitely went through everything that's relevant. Hopefully this presentation was helpful. I don't think any questions have come in as of yet.
Yep, absolutely. So if you do have questions, feel free to reach out, schedule a consultation. Keep an eye out for that email that we'll send after this presentation. We really do hope to hear from you. GA, thank you for taking the time and sharing your expertise, and thank you to those of you in the audience for joining us today. Stay well.